Thank you for attending our first panel in the Ohio's Opioid Settlement Panel Series titled Addressing Harm, Opioid Settlement Background and Historical Context, co-hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law and Harm Reduction, Ohio. Before we begin, we have just a few notes we'd like to share with you. First, to streamline the appearance of the event today, we suggest that you hide non-video participants. To do that, click on the three dots at the top right corner of any participant box that has their video off and click Hide Non-Video Participants. Second, we want to draw your attention to the Q&A function at the bottom of the Zoom window. You may submit questions at any time during the presentation. Third, please note that auto-generated transcription has been enabled for this event. To change how you view the automated transcription or to hide it, click Live Transcript in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and social media channels as soon as possible after the event. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the event. Dennis?
Thank you very much, Holly. I will share my screen. Thanks very much, and thanks to the Ohio State University and the Moritz College of Law and the Drug Enforcement Policy Center and the panelists, who I think really show interdisciplinary scholarship at action. You'll see with the three different perspectives from the panelists all coming together in the Drug Enforcement Policy Center really illuminates what's going on. And I'm a former national reporter at USA Today, and I founded Harm Reduction Ohio in 2017. So we're a statewide organization that works to reduce overdose death. We're also the largest Project Dawn naloxone distributor in Ohio. We'll distribute about 30,000 kits this year and reverse about 5,000 overdoses. But as you can tell, that's not enough because overdoses were 5,000 last year and on track to be another 5,000 this year. So the panel we're discussing today is both important and topical. And it's topical because in the last week or so, there's been two important legal decisions in favor of the pharmaceutical industry. But what we're talking about today is the settlements that have been reached or are on track to be reached. So nationally, they're going to be worth up to $50 billion. For Ohio, that will mean about $1 billion to $2 billion. So how much will Ohio get? This is sort of the key ones that have already been settled. The distributors, Cardinal Health of Dublin, McKesson, and another distributor will provide $800 million over 18 years. J&J, former opioid manufacturer, $370 million over 12 years. And so total, it's about $1.3 billion. And it's a little difficult because each are paid over different amounts to say what's the value, but if you do net present value, discount back the flows, it's probably about $750 million that's been agreed to, which is pretty substantial. And this doesn't count the Perdue Farmer and Sackler family settlements, which if approved as they are now, would be in the 5 billion range or so, and Ohio would get maybe 450 million. Plus, as you probably know, right now in federal court in Cleveland, the pharmacies are in court with two counties. Giant Eagle settled, but CVS and Walgreens, and they're defending themselves and have not settled. So who will get the money? Overall, I think the structure makes a lot of sense. Whether it can hold is a question Micah and the lawyers will talk about. So 55%, the majority of the money will flow into the One Ohio Foundation, which has not yet been created. It's a 501c to be a 501c3 nonprofit, but the bylaws haven't been created. It's very general how it will work out. Local governments will get 30%, which flows directly to the 2,000 plus local governments. So some governments will get like $1.5 million. Other governments will get $57. like little villages and townships. And the state of Ohio will get 15%, which is substantial, but I haven't been able to find out who gets the money. Does the governor, the legislature, the attorney general? It's vague in the agreement. The only thing that's really well specified in the agreement is how much the lawyers will be paid, where and when. That's got a lot of clarity to it. So the One Ohio Foundation is sort of like 19 mini foundations. The money is supposed to be dispersed equitably, even though it's coming through the foundation. And there are 19 regions, each will have its own board, which how they will be created is totally up in the air. It looks like they're probably going to use an Ohio Revised Code Council of Governments form, but even that requires everyone to agree to it. There's no bylaws, and so we're kind of on deadline because the money's supposed to start coming in later this month or next. So the agreement says there's a 29-member governing board controlled by government officials. Governor DeWine appointed 5 last Friday. The others are still unknown. And then these as yet formed regional boards will appoint other boards. And then there's a 9-member expert advisory panel, 2 of which the governor appointed. And all these are crucial, are crucial to determining how it actually plays out. Overall, I'm optimistic. Micah may be less optimistic if you look at the tobacco settlements as history. The only concern I have right now is that there's no requirement that people who are impacted by the opioid crisis be represented. And the first 5 members appointed have no one who has any lived experience with drugs, no family members who lost someone to overdose. They're all, Senator Portman's spouse is one of the person, a former Lucas County Sheriff, who's a good person, and a Vice Mayor of Cincinnati. All those are good people, but I think it's hard to imagine if you had a settlement for racial justice that it wouldn't be expected that Black residents are going to be on the board. But right now, there's no mechanism. There's nothing preventing people who are impacted from being on the board, but there's nothing that requires it. And so that's something I've been promoting. And I think it's particularly important, not just legally, politically, also morally, because Ohio got more than its share of the population because of our high level of overdose death. And regions will get more than their share of the population if they had high overdose deaths. So literally the amount of money is on the backs of the people who died. So representing the impacted population is crucial, not just giving it to the establishment who is well-meaning. So that's my one concern. So I think that sets it up. 1-2 billion is a lot of money. It's, it's not tobacco fund money, but it's still pretty substantial. So we have 3 great panelists today. And the first one I want to introduce is Tasha Perdue, who's a social worker and assistant professor at the John Glenn College of Public Affairs, who's done a lot of research in opioids, in people who use drugs, and she's going to sort of set up the opioid crisis context for us.
Great, thank you, Dennis, and thank you all for attending the first panel in a series that we're hosting on Ohio's opioid settlement. And as Dennis mentioned, I'm in the John Glenn College of Public Affairs, and prior to my PhD, I did work for the Ohio Department of Mental Health and Addiction Services, and I reported on drug trends for the Dayton region, and I also returned to the Dayton region for my dissertation. So I'm going to be providing a little bit of background context on the opioid crisis in general. Some of this may be a review, but we want to provide a framework for the rest of the panel series. So one of the main drivers of the crisis was a movement in the 90s to have pain recognized as a vital sign. So the other vital signs are things like temperature, breathing, heart rate, and these are all things that we have tools that we can measure, and we know when individuals are in range or if they're falling out of range. Pain is a little more difficult to measure. It's a more subjective experience individuals have. We do have a pain assessment tool that you can see on the screen, and many of you may have had to kind of gauge your pain level when you go in. Maybe you've been to the emergency room or to the doctor's office, and it can be kind of difficult to kind of gauge where you fall on this scale. Also, individuals experience pain differently. There's different pain level tolerances, so it made things very difficult when making this transition. Paired with this, now that we have pain being recognized as a vital sign that needed to be treated, the pharmaceutical companies started aggressively marketing prescription opioids. And within their marketing, the pharmaceutical companies identified that there was limited addiction potential associated with these pills. So, and these were based off of studies, or one wasn't even really a study, it was a 5-sentence paper that was submitted that said there was limited addiction for patients being treated with the pharmaceutical pills, and even over long-term use, that the threat of addiction was very rare. So with this push from the pharmaceutical companies, we did see an increase in the number of prescriptions being written here in the US. So one study estimated we had over 100% increase in the number of prescriptions being written just from 2000 to 2010. And it wasn't just that we're having more prescriptions being written, it was that there were higher milligrams of prescriptions, so higher morphine milligram equivalents being prescribed to people. So these are very, very potent pills being prescribed, and these were being prescribed for longer lengths of time. So this was increasing the potential for addiction among these individuals. And by 2010, there were enough prescription painkillers were prescribed to medicate every adult in the US around the clock for an entire month. So these were flooding communities. And this was a big drastic shift in how prescription pills were formerly prescribed. They were limited primarily for terminal illnesses and cancer-related pain. So this was a shift in prescribing them for more chronic pain, such as back pain, in these patients. So within Ohio, I want to provide just a brief timeline over what the opioid crisis has looked like here in the state. And this is not an exhaustive timeline, but I just wanted to touch on some key moments and years within the state. So starting in 2003, the Ohio Substance Abuse Monitoring Network identified that there was an increase in opioid use in Ohio. And they submitted a letter stating that there was a probable relationship between prescription opioid use and subsequent heroin use. So this was back in the early 2000s that this was identified. By 2005, we're seeing prescription opioids involved in the majority of opioid-related overdoses here in the state. And then by 2007, unintentional drug poisoning deaths surpassed motor vehicle crashes as a leading cause of unintentional death for the first time in the state. And this was unheard of. For years, motor vehicle crashes were the leading cause of unintentional death, not only in Ohio, but in the US as well. We did start to see some efforts to address the prescribing practices. So there was a pill mill law in 2011. There was some state level action through an opioid action team that was created. And then by 2012, we do see heroin related overdoses surpass prescription opioid related overdoses in the state. And this was during the time period that I was working for the state and covering the drug trend reports. And it was from 2011 to 2014. So I was right in this time frame. And I interviewed individuals every 6 months. And I definitely, you could see this sort of shift in use and also availability between prescription opioids and heroin. We did see some expansion through Medicaid. So individuals were able to access treatment that weren't initially able to. And also naloxone expansion within the state. So naloxone or Narcan, which is the opioid reversal drug. Much of the attention that we do focus on overdoses, but I do want to note, we have seen increases in hepatitis C within the state as well. So between 2011 and 2015, acute hepatitis C increased 1,000% within the state. And then by 2016, fentanyl-related overdoses surpassed heroin. And when we mentioned fentanyl, this is not the Duragesic patches or pharmaceutical fentanyl that is provided by the doctor. This is a illicitly manufactured non-pharmaceutical fentanyl. And there's many different analogs, and all the analogs have different potency levels of fentanyl. That's what makes it so dangerous. By 2017, we reached a record of overdoses in the state. It was almost at 5,000 overdose deaths, and many areas in the state received national attention. You may remember news stories of morgues being at capacity and cold storage trucks being used. And we did see some additional efforts related to prescription management. So prescriptions were limited, and there was additional oversight that was added in 2017 as well. We did see a slight decrease in overdoses in 2018 due to many of the efforts that we had as far as naloxone expansion, but also changes in the drug market and the availability of carfentanil being a little bit lower. 2019, we saw a slight increase, but 2020 is when we really saw overdoses surpass what we saw in 2017. We reached over 5,000 overdose fatalities within the state. And as Dennis had mentioned, we're on track to meet or even exceed this number for 2021. And that brings us to 2021, which we reached the $26 billion opioid settlement. So the efforts that we've seen within the state on prescribing, we have seen changes in prescribing rates over time. So this chart shows the overall prescribing rate for people in the US. That's the blue line at the bottom. And you can see the orange line is the prescribing rates within Ohio. You can see we've been higher than the national average, and even at some points topping over a rate of over 100 per 100 persons. And we have seen a shift and a drop in prescribing rates over time. Within the state, there are still some areas that have a higher prescribing rate than the state average, but we have seen kind of a change in this over time. With the drug overdose deaths, so you can see the blue line at the top is the drug overdose over time in Ohio. You can see the increase into 2017, the slight decrease, but then in 2020, surpassing what we saw in 2017. And then as far as the opioids involved, you can see the prescription opioids is the line in orange, and that was initially the highest rates from prescription opioids. And then heroin surpassed the gray line, surpassed the prescription opioids, but then we see fentanyl emerging, especially in 2016. And now the majority of overdose related deaths in the state are related to fentanyl. And we're seeing fentanyl contamination, not only within heroin, but also within other substances, methamphetamine, cocaine, as well within the states that is contributing to these overdose rates. So I do want to provide a few stories from the individuals that I talked to during my dissertation. So as I mentioned, I did return back to the Dayton area, and I conducted in-depth interviews with 60 individuals in the Dayton region, and really wanted to hear their stories about their experiences and their transitions and how they're managing risks in this environment. So participants, when talking to them about their initiation, the majority did follow the trajectory of prescription opioids to heroin and then in fentanyl, with the average age of the individuals I talked to initiating into prescription opioids around 20, heroin around 24, and street fentanyl around 30. And many echo those that started obtaining or started with prescriptions from the doctor, not really receiving any information over associated risks with these. And it's likely that the doctors were unaware of the risks as well due to the marketing from the pharmaceutical companies. So in this participant's words, she talked about how she initially received the prescriptions from the doctor, but he never talked to her about any of the dangers associated. So in her words, no, he didn't say a word. And I didn't, like I said, I'd never done drugs. I didn't realize, well, I was a grown woman. I should have realized when someone says, hey, you should take a couple extra of those, that addiction would come. But I had never been around addicts in my family. I'm the only one in my family that does drugs. So I'd never been around addiction or addicts, so I didn't know. And so, but he never told me about risks or anything. For those participants that did receive, participants did report maybe receiving pamphlets or something from their doctors, but many reported, just not really taking time or not being able to review or to read that through that. And then participants talked about just abrupt discontinuation of their prescriptions. So just having the access and their doctors not really providing any sort of methods for them to, referrals or resources provided. So individuals would then talk about, either going to purchase prescription opioids through the street, or even then purchasing directly, going into purchasing heroin. So this participant, he talked about, being told by his doctor that the prescriptions he was no longer going to be provided them, and then just what he went through. So in his words, well, they tell you the prescriptions are going to stop, and then you're like panicking. And then I'm like looking for it, trying to buy it off the street. And then it's just, heroin was just there because I know everybody that gets high. So I knew people that got heroin, and then I went straight to it. And this was also reflected in this participant. So he talked about being fired by his doctor, and many participants use this sort of language. They were fired by their doctor, and just his wish that he had been provided a referral. So he talked about if he had maybe been aware of methadone or other treatment options, that maybe he could have went to those as an option, versus he said he started doing heroin when he was fired. So in his words, that's the time period that I started to get on heroin then, because I was 27. I had a habit of doing opioids since the age of 14. And at that time period, I was being prescribed 2 Oxycontin, 50 milligrams a day, and had been that way since the last 10 years. And so that's when I started doing heroin. Then later on, I found out that there was a methadone clinic. I kind of wish that I would have been more informed by my doctor. When my doctor was going to fire me, I wish my doctor, he would have maybe, or the nurses or somebody would have known about a methadone clinic and would say, hey, look, you can at least go get it. Go get methadone and you'd be all right. And then finally, I really want to highlight the traumatic experiences the participants that I talked to have lived through. And over half of participants reported either experiencing a serious car accident, the sudden or traumatic death or loss of a family or friend, or sexual or physical assault. And this wasn't often just one experience, but repeated experiences since childhood. So just the use not only for physical pain management, but also that sort of emotional pain management component. And this participant, she spoke about losing her brother. She referred to him as her best friend, and the loss of him paired with a car accident, she talked about really influencing that trajectory. So she says, I was emotionally unstable and physically in pain. So when I ran out of those prescriptions is when I turned to the dark side, you might say. My brother died in a car accident, and I was in the car. I was a passenger. And then the car he was driving, and the car that was hit, another person died. So it was a lot of grief for me, and shame and guilt. So emotionally, that's how I was emotionally unstable. And then I was, it was a pretty bad accident. So I was in a lot of pain, and I had a lot of injuries, the combination of both. So I really wanted to highlight these participant experiences, because as Dennis says, hopefully as we move forward within the settlement process, that we can bring these voices to the table, and that they can really have a part in how the funds are being spent in Ohio. So again, would like to thank you. And at this time, I'm going to turn it over to Patty, who's going to provide a little bit more background over the opioid settlement.
Thanks so much, Tasha. So I do not have slides, so I'm not going to be sharing my screen. But thanks again, Tasha, for that helpful discussion of the impact of the opioid crisis on Ohio and the nation. As Tasha mentioned, today's panel is the first in a series of 3, and we're aiming to discuss the basics of what has happened with the opioid litigation and the recent settlement. I already see some great questions in the Q&A, so please continue to go ahead and type them as we go. As Holly mentioned, we'll discuss audience questions at the end. So I'm going to use my time to sort of give a basic overview of the history and the landscape of the opioid litigation, who the plaintiffs and defendants are, and what kinds of claims have been brought against the defendants before I turn it over to Micah to talk more about the recent settlement. I'm also generally going to focus on civil litigation. Do note, however, that there have been numerous criminal cases brought against both healthcare professionals and companies involved in the manufacturing, distribution, or prescribing of prescription opioids, as well, of course, as criminal cases brought against those involved in the distribution or possession of illicit opioids. On the prescription side, criminal cases, as I said, have been brought against both physicians and pill mill operators, as well as the big names we know manufacturing prescription opioids. For example, way back in 2007, Perdue Pharma, the manufacturer of OxyContin, and 3 of its executives pleaded guilty to criminal charges related to the misleading promotion of OxyContin. But let's turn to the civil litigation. So civil litigation in the opioid space, like criminal cases, is not new. Litigation started about 20 years ago, around 2001. Some of the early litigation in this first wave was brought by private people who were harmed by opioids, or the families of people harmed by opioids brought cases on their behalf. And these cases were primarily brought against Perdue, asserting relatively straightforward products liability or torts claims related to arguments that OxyContin was defectively designed or that warnings about OxyContin were inadequate. And experts actually typically cite an Ohio case as the first case of these cases brought by private people in the first wave of litigation. That case was a wrongful death action brought against Perdue Pharma in April 2001 on behalf of a woman named Jackie Renee Burton, who was from McDermott, Ohio, in Scioto County, and who died of an overdose. So thousands of these claims were brought, as well as some class actions. And in these early, in this first wave of litigation, but the plaintiffs did not fare well for a number of reasons. One obstacle that plaintiffs faced, for example, was that successfully arguing that an FDA-approved product is defective or unsafe in its design is pretty difficult. After all, FDA has approved the drug as safe and effective. Another example of an obstacle that plaintiffs faced is that arguing that a better warning on the product would have prevented the plaintiff's injury also could be difficult. Would a stronger warning about addiction have meant that the physician wouldn't have prescribed an opioid pain reliever, or that the physician would have prescribed a different product? Would that really have changed what happened with the plaintiff? Or at least courts were skeptical of that. A third example of the kinds of challenges that private people faced in these early cases or in this first wave of litigation was showing causation. So how could plaintiffs show that any one specific manufacturer caused their injury when perhaps they were prescribed multiple drugs, and many of the people bringing these cases were stigmatized for their substance use disorders? So there were some victories in these early private lawsuits, but overall plaintiffs were not largely successful. During this first wave of litigation, there was also civil litigation brought by governments instead of individuals. So for example, in 2001, West Virginia brought claims against Perdue, basically arguing that Perdue had engaged in deceptive marketing of OxyContin, which Tasha talked a little bit about. And those claims ultimately settled for $10 million. Now, $10 million is a lot of money to those of us in the Zoom room, right? But it's not a lot of money to Perdue Pharma, nor is it actually a lot of money to enable a government to meaningfully address the harms of the opioid crisis and really help people. Likewise, in that time period, there were some other small settlements with Perdue. Kentucky obtained about $24 million, and there was a class action involving 26 states and the District of Columbia that settled for only about $19.5 million. So that was the first wave of litigation. The second wave of litigation is what many of us have probably heard a lot about, especially in recent months. And 2014 is typically described as the start of the second wave of the opioid litigation. In 2014, the state of Mississippi and the city of Chicago were the first government entities to bring suits in the second wave. And after those two government entities sued, other states, including Ohio, as well as 2,000 or more than 2,000 local governments also sued. And in this second wave of litigation, the defendants were more diverse than in the first wave. So instead of a focus on Perdue alone, Plaintiffs also sued numerous other manufacturers of opioid analgesics or opioid painkillers, including Insys, the maker of Subsys, a sublingual fentanyl spray, Endo, the maker of an extended release oxymorphone product marketed as Opana ER, and Johnson & Johnson, the maker of a fentanyl skin patch marketed as Duragesic, among others. Insys you may have heard of because they've been subject to criminal prosecution as well for their marketing of Subsys. And there is a truly egregious rap video that was used for marketing the drug, which is now available on YouTube and in some of the news stories about the criminal prosecution, and that I show my students in my FDA law and policy class when we talk about prescription drug marketing. Anyway, in this second wave, in addition to suing manufacturers, plaintiffs also sued the 3 largest drug distributors. As Dennis mentioned in the beginning, Cardinal Health here in the Columbus area, McKesson, and AmerisourceBergen, which together distribute about 85% of all the drugs distributed in the United States. And that $808 million settlement that the Ohio Attorney General announced in September of this year is with those 3 distributors. So, and then in addition to the manufacturers and distributors, plaintiffs also sued a 3rd category of defendants, retail pharmacies like Walgreens and CVS. So the plaintiffs, who again in the second wave are generally government entities, have broadly alleged that as government entities, they are spending tremendous amounts of money, billions of dollars, to address the harms of the opioid crisis, and that those harms are caused at least partly by defendants' wrongful conduct. The specific legal claims that are involved in the different lawsuits are varied, but generally they include arguments like, for example, that the defendants have created a public nuisance, meaning that defendants engaged in unreasonable conduct that interfered with the exercise of a public right, which, depending on state public nuisance laws, could include interfering with public health or public safety. Another example of a kind of claim that plaintiffs have brought is that they've argued that defendants have violated various state consumer protection and unfair competition laws by, for example, the kinds of misleading advertising and promotion that Tasha mentioned. Another sort of category of arguments that plaintiffs have asserted is that defendants have violated anti-racketeering laws like the Federal RICO Act by basically setting up an illegal coordinated scheme to profit. And a 4th example of the kinds of arguments plaintiffs have made is that with respect to the distributors and the retailers, that by failing to monitor, detect, and report suspicious shipments or orders of prescription opioids, those distributors or retailers have not satisfied their obligations under the Federal Controlled Substances Act, and according to plaintiffs, also under state common law. So that's sort of what's happened in the second wave of litigation, and there undoubtedly has been more success in the second wave of litigation, including, of course, the recent settlement. But plaintiffs have still faced significant challenges. For example, just last week, local governments in California suffered a setback in their public nuisance claims against opioid manufacturers. In that case, a judge rejected arguments that there was evidence that an increase in opioid prescribing during the relevant time period was medically inappropriate. And the judge basically reasoned that even if the manufacturers had engaged in misleading promotion, that any consequences flowing from medically appropriate prescribing could not constitute a public nuisance under state law. And likewise, just yesterday, I believe the Oklahoma Supreme Court threw out a $465 million verdict against Johnson & Johnson. Again, sort of similarly reasoning that the state's public nuisance law does not extend to the manufacturing, marketing, and selling of prescription opioids. So the second wave of litigation in sum has involved a more comprehensive set of defendants. Plaintiffs have seen more success in the second wave of litigation than in the first, but there are still challenges that plaintiffs are facing in bringing these cases. So with that overview of the litigation, I will turn it over to Micah to talk more about the settlement.
Thanks so much. Let me get set up here for 1 second. Okay, so I'm gonna talk largely about the history of the tobacco settlements and then talk a little bit about the recent opioid settlements and some of the questions that I have about the legal issues that will hopefully be explored in some of the future panels. So most of what I'm going to say is discussed in this article that I published a couple of years ago in the Kansas Law Review. It was part of a symposium of articles that were mostly about the opioid litigation. So they're a little bit dated now, but if you are interested in diving into some of the legal issues a bit more, there are some good pieces in this symposium issue. So as I said, I'm going to talk about the tobacco settlement, which was reached between nearly all of the state attorneys general, and the major tobacco companies, and the lessons that we can try to learn from that about how to ensure that the money from these newer opioid settlements is actually used, or at least much of it is used on prevention and treatment. So the settlement happened in 1998. If you didn't believe that it was in the 1990s, this picture should convince you that it was back in the 1990s. These are the state AGs who spearheaded the litigation. The one out in front is Michael Moore, who was then the Attorney General of Mississippi, which filed the first lawsuit, and then he led the effort to organize the other AGs to sue the tobacco industry, and ultimately every single state Attorney General did sue the tobacco industry. Michael Moore is now in private practice, and he has been a key player in that role in the opioid litigation. So it's no coincidence that, as Patty mentioned, Mississippi was again the first to file the lawsuit here. And I was actually amused to find when I went to his website that he is still 20 years later standing with the same pose as he was in that picture. But to go back to the tobacco litigation, the premise was similar to what Patty described for the opioid lawsuits, in that the states were suing to recover money that they had spent on treating smoking-related illness through Medicaid and through other state programs. For the tobacco litigation, it was just the states, so it was a little less complicated. It was just the states, and they were only suing the manufacturers, so there were fewer players involved. 4 of the states had reached separate agreements with the tobacco industry in 1997, and then the remaining 46 states all joined what became known as the Master Settlement Agreement, or the MSA, in 1998. And the settlement was a huge deal when it happened. It was and still is the largest settlement in the history of US litigation, but it's now more than 20 years ago. So I'm finding that my students know very little about the Master Settlement Agreement, if they've even heard of it at this point. So I think it's useful to go over the history a little bit. So just to outline the agreement in broad terms, it was a lot of money. It was $206 billion paid to the states over 25 years, but the payments actually don't stop at 25 years. They go on in perpetuity, and those payments are tied to the volume of cigarette sales, which you might immediately recognize create some problematic incentives for states that are relying on this money as part of their budgeting. It also included various restrictions on conduct, restrictions on tobacco marketing, so prohibiting billboards, prohibiting some sports sponsorships, prohibiting the use of cartoons in marketing. It famously put Joe Camel, the mascot, out of business, and so forth. So I'm going to talk mostly about the money part, but there were restrictions on tobacco marketing as well. There was industry document disclosure, which has been incredibly, incredibly important for research and advocacy purposes over the last 20 plus years since that settlement was reached. There was $1.7 billion in the agreement, which was set aside for a national foundation that's now called the Truth Initiative, that does what we call counter marketing against the tobacco industry. And that's a relatively small part of the overall settlement, but I have it highlighted here because I think it's actually been, from a public health perspective, that 1.7 billion has gotten probably more of a return on investment than almost any other part, probably any other part of this agreement. And then states, of course, as part of the settlement, waived their future claims against the tobacco companies. So there were numerous whereas clauses in the agreement saying that the purpose of the funding was the advancement of public health and programs to reduce youth smoking and assist with cessation and so forth. But there was nothing in the agreement itself in the actual operative clauses that required that. So you could go back and see when this agreement was announced, the AGs and the governors in pretty much every state said this is what the money was going to be used for, but that was not actually a requirement of the agreement. And so the AGs, the people who were the AGs at the time, have said that it was not part of the agreement itself because they didn't think, or at least they had questions about whether they could legally include it as part of the agreement. So, in their view, they were suing on behalf of the state for money that was spent by the states. The money was then recovered by the states, and it was up to the state legislatures to then determine how the money would be spent. And so the AGs would say, they were trying their best to signal that this is how, this was their understanding of how the money should be spent, but they were not the people who legally could mandate how it was spent. And so that's a really important and really, I think, unclear legal question as to whether or not they were right that they couldn't directly allocate the money. So we will get back to that when we talk about these opioid settlements. Last point on this is just to say that I think it was reasonable that not all of the money would go towards public health and prevention and cessation because this was a cost recovery lawsuit. So some of the money arguably should go back to the state to reimburse it for money that had already been spent. But as I said on the previous slide, what this agreement does is it waives the rights to all future litigation. So both here in the tobacco context and in the opioid context, if you're not using the money to address future costs, then you will keep incurring those future costs, but will be unable to recover for them in the future. So what happened to all of this money from the settlement agreement that was sent to the states? The short answer is that it has been spent on everything imaginable, but very little of it has actually been spent for the purposes articulated in the agreement. So it's hard to, this is a figure from the Campaign for Tobacco-Free Kids. It's hard to disaggregate tax revenue and settlement revenue because in many states, it just all gets poured into the general fund and then some of it gets allocated for tobacco prevention. But whether it's tax money or settlement money, very little of it gets spent on tobacco prevention and cessation. So you can see in this is data from last year, states brought in 26.9 billion from those sources and then spent only 656 million on tobacco prevention cessation. And just to put that in context, the tobacco industry spent more than $8 billion on marketing just last year. So let's talk about how this happened. And I'm going to focus primarily on Ohio because we're here, but also because I think it's a pretty good example of how things happened across the country, and also because I lived through it to some extent. So Ohio, under this agreement, was and is scheduled to receive more than $10 billion from the master settlement agreement over those first 25 years of the agreement. And again, the payments go on in perpetuity. So Ohio, led by the Attorney General who signed the agreement, who was Betty Montgomery, and the governor at the time, who was Bob Taft, came into office pretty soon after the agreement was signed. They brought together a task force that helped make a plan for spending the money. That was the basis for legislation that was called SB 192 that was passed by the legislature in the year 2000. And most of the money under that plan went into the general fund, again, as reimbursement for past smoking-related costs. But the law also created different trust funds to allocate money for different purposes, and the largest one was for was supposed to be for tobacco prevention and cessation. And as part of that, the legislation created a foundation that would spend that money called the Ohio Tobacco Prevention Foundation. And under the plan, it was supposed to receive $1.26 billion between 2000 and 2012, and then run in perpetuity off of the endowment from that amount into the future. So this bill was passed with bipartisan support. It arguably was a sensible plan. Some objected that there should have been more money on the prevention and cessation side. But what actually happened is that the foundation received its first payment of $330 million. The payments were sort of front loaded so it could get up and running. Received its first payment of $330 million, and then payments in every single subsequent year after that were diverted either back into the general fund or to other programs. So nonetheless, the foundation had a good amount of money to start with. It got up and running. It followed CDC best practices. It showed, I won't go through the numbers, but it showed just incredible results in reducing both youth smoking rates and adult smoking rates. One of the things that it did, and this is where I come into the story, is that it put a focus on policy change. So it funded local tobacco control coalitions all over the state to work on policy change to reduce tobacco use and secondhand smoke exposure. And it hired me to create the tobacco Public Policy Center to provide legal and policy support to those communities. So that was an incredibly fun job. I actually, if we have any more students on, Dean Neely also worked with me at that time at the Policy Center, supporting communities around the state doing that. In 2007, as the state's financial outlook got bleaker, the state went beyond just diverting the payments and actually securitized future payments, which meant that it sold off the rights to receive future payments to bondholders in exchange for a large upfront lump sum payment. So that raised about more than $5 billion, so about half of the anticipated amount. And that was promptly spent as part of a stimulus bill. So that means that since 2007, Ohio does not actually get the benefit of any of these MSA payments that come in anymore. So the money comes in, but then goes right out the door to bondholders. And that's happened in about half of the states, that states have at least to some degree securitized their future payments. That wasn't the end of the story. In 2008, the economy got even worse. The governor and legislative leaders said to the foundation, we see that you have about $200 billion left in your bank account, and we would like that money back, and we will just fund you on annual appropriations thereafter. And the foundation said, no. They said, according to the statute, the money is not the state's money anymore. It is part of the foundation's money. You can't just take it back. Relying on appropriations, given what has happened over the previous year, seemed like a bad idea. So we're not going to give you the money back. And the legislature and the governor said, if you're not going to give us the money back, we will just shut down the foundation entirely and take it back. And that ultimately is what they did. That action got tied up in litigation for a number of subsequent years, but ultimately the court upheld that action and the foundation was abolished. And so, what you saw between 2000 and 2008, in 2000, you saw an overwhelming bipartisan majority to put this plan in place and fund tobacco prevention and cessation in a sustainable way. And just 8 years later, you had, again, an overwhelming bipartisan majority vote to dismantle that foundation with pretty terrible public health consequences. The reductions in smoking that were driven by the foundation stopped, and in some cases reversed after the foundation was no longer in place. So the lesson in my mind is that even with the best laid plans and a framework that the legislature was strongly supportive of, you cannot count on a future legislature to actually follow through with implementing those plans. Ohio, as I said, is pretty typical. I won't go through the other states where similar things happen. I just wanted to mention Florida real quickly, which has been a rare exception to the rule that this money has not been used for its intended purpose. What happened in Florida is started out as a similar story where money was used for tobacco prevention and then it was taken away by the legislature. But in Florida, the major public health groups got together and proposed an initiated constitutional amendment that they sent to the voters that would require a substantial portion of the settlement funds to be used for tobacco prevention. Florida requires 60% of the vote for a constitutional amendment to pass. It passed with 61% of the vote. So it requires funding tobacco prevention programs with 15% of the amount received from the settlement, which turns out to be quite a lot of money every year. And that has been incredibly impactful in Florida, where the youth smoking rate is now the third lowest in the country, behind California, which did essentially a similar thing, but with its tax money. So again, lessons learned is that good intentions, verbal promises, even legislative promises are not good enough. There needs to be a mechanism to actually lock up the money to be used for public health. I would say success is also not enough. The fact that these programs were successful did not keep them from getting gutted over time. The only things in the tobacco context, at least, that seemed to work were one, sending some of the money to a national foundation so that it never got to the states and was not allocated by the state legislatures. And then constitutional amendments. I think very interestingly, according to a memo that Dennis helped uncover, the Ohio Attorney General's office came to the same conclusion that the only way to actually ensure that the money would be spent for public health purposes was to have a constitutional amendment, but that did not happen in Ohio. Instead, they reached these agreements. And so just real quickly talk about these opioid agreements. These settlements do purport to bind the state as to how the money can be spent. So this first paragraph is probably hard to read, but if you look at that second sentence, it says, in no event may less than 85% of the settling distributor's maximum amount of payments pursuant to these various sections be spent on opioid remediation. So it is requiring, if you actually do the math, it's 85% of about 85% of the money. So it comes out to about 70% of the money in the agreement is supposed to be spent on opioid remediation, which is then defined in the agreement. This is from the distributor agreement, but there's almost identical language in the Johnson & Johnson agreement. But this, as I said, was what the attorneys general said that they couldn't do 20 years ago. So it is unclear to me that the attorney general can bind the state and bind future legislatures in this way. The money, or at least some of the money, is going to the state legislature. And it is unclear to me that this settlement agreement can truly bind what a legislature or future legislature can do with the money. The second really interesting thing here is what Dennis talked about before, this One Ohio idea, where Ohio has this separate, it's state-specific agreement as part of the settlement, and that those settlements, again, with the distributors and with Johnson & Johnson, require the money to be sent directly to this private, or at least quasi-private foundation, this One Ohio Foundation, that was not even in existence at the time of the settlement agreement and does not appear to be fully in existence yet either. The idea is that that would again protect the money from being spent and reallocated by the legislature, but I think this is also untested legally as to whether or not they are able to do that. So, I think the Ohio Attorney General and other AGs, did try to learn the lessons of the tobacco settlement and try to ensure that the money, or at least most of it, would be spent on addressing the opioid crisis. But I think there are a lot of unsettled legal questions here. So I'm not trying to stir up any legal challenges, but I think we are in uncharted waters in terms of whether AGs can do this, even by the admission in their memos of the Attorney General's own staff. So I think the last point, even if you think this particular settlement sets out a good framework, and it's great that this money is being protected from diversion, this is a valid approach for attorneys general to use. It is easy to imagine an attorney general using a legal settlement to spend money on their own personal pet causes in ways that might be much more problematic. So I think that broader structural perspective needs to be thought about as well. So I think the future panels are going to talk more about how this money is going to be spent, but I hope we can have some discussion on those panels as well from the people who were involved about how they thought about these legal issues and the ability of the Attorney General to protect this money from being diverted to other purposes in the future. So I will stop there and look forward to the discussion.
Thanks very much, Micah and Patty and Tasha. I'd encourage people to put questions in the Q&A, and I'll relay them to the panelists. And I'll just ask, like Micah and Patty, the law professors, a little bit about what you touched on at the end. Is the lawyers who negotiated this made a special point when talking about it, that they had learned the lessons of the tobacco settlement, and they had made changes that put it not quite in a lockbox, but more of a lockbox. Do you think that, are there significant technical changes they made to protect it more, such as in Ohio, 30% going local? I presume the legislature can't get that back. And even One Ohio is sort of like 19 local government-ish, or is really the legislature without a constitutional amendment. It's nothing you can do.
I'll defer to you, Micah, if you want to.
Yeah, I mean, as I said, they tried, and the question is whether a legislature at some future date is actually going to challenge them on this. And I mean, I think the legislature would be the most obvious people with standing to challenge it on the theory that this is actually the state's money and it is their job to decide how the state's money is allocated. So I mean, I think there definitely were calls. It was through this process. It was in a bit of an opaque process, but there were public health groups kind of on the outside trying to push for the money to be spent sort of like this, like sent to anyone but the legislature, so that it would be out of the legislature's hands and they could not divert it in the future. But sending it to this foundation that is not set up yet is a creative way of doing it, but it's a totally new way. So I think there is absolutely no case law out there on whether or not this would hold up. I mean, there is, and you can kind of look through the agreement and see the mechanism that the money gets sent to a settlement administrator who then distributes it to the various places that it's supposed to go throughout Ohio. So, according to the agreement, the money, I think, never touches the state. It's never on the state's account, at least the money that's supposed to go to this foundation. So if they want to stop this agreement from going into place, if they want to divert the money to something else, it's probably going to require a lawsuit to try to invalidate this agreement or declare that the money goes to the state.
It seems to me that the structure in the agreement of the One Ohio Board is politically rather astute. It includes the legislative leaders of both the House and Senate, and in both parties, the governor and the attorney general. So at least they will have a stake. I don't know if that was the thinking, but it seems like that may be a practical effect, that they'd be working against themselves.
Yeah, I think absolutely. If you want to keep them from challenging it, then getting them on board and to have some buy-in and to get to name the people who are on this board, I think was a very smart idea. And they were involved. You probably know more than I do, but I mean, they were also involved in the discussions to some extent of setting up this framework. So it's not like they were completely cut out from the process either.
Yeah, and local governments are not powerless when it comes to influencing the legislature. So I think politically, if not legally, it would be tougher to loot to loot the money. Another question for Patty and even Tasha and Micah that we have is, how will One Ohio be held accountable to actually do a good job? What are your thoughts on that?
Yeah, I mean, I think that's a really important question. And as I think Micah touched on in his presentation, I think it's not entirely clear, right, how One Ohio will be held accountable and to whom. And I think Dennis and Tasha, you touched on this with your comments as well, that it seems as though there are not on the board, there are not people who with lived experience using drugs included. And so, I think the question is how to hold One Ohio accountable and who should be involved in that process and sort of which voices get to be part of that process.
What do you think, Tasha?
Yeah, I mean, I agree with what Patty was saying. I think it is really important to have those who have been affected. So those with lived experience, the family, and I think that's a way to have accountability. So to have, the voices from community members a part of this, I think that's one way that we can kind of ensure, more accountability for this organization.
I do think one thing that will increase accountability, although it's a 501c3 nonprofit, the agreement does require that it's covered by open records and open meetings law. So it will be quasi-governmental in that sense. And so I also think that with the size of the overdose has more of a political constituency trying to deal with it, not just mental health boards, private groups, us, other groups than tobacco, which was sort of vaguer, like do-gooder public health and maybe the American Cancer Society. So I do think there's a lot of, and even, treatment clinics have a lot of money and a lot of influence and are deeply involved. OMAS, the Ohio Department of Mental Health and Addiction Services, where I used to work, and the Ohio Department of Health, which runs syringe programs and naloxone. So there's a lot of stakeholders, and there's a lot of money spent on overdose prevention, whereas this would have sort of been new money for tobacco. If they take it away from here, then they almost have to spend it elsewhere. So there's not sort of that net savings. And I believe you may remember the number is like they can already spend 15% of it or some certain percent of it on other stuff. And they can also send 10 or 15% to reimburse themselves for past expenses, which is sort of like spending it on. So there's a little leeway in there. So we've got a question on standing. Who would have standing if Ohio state legislators allocated opioid settlement elsewhere and away from One Ohio? Who would have standing to challenge that?
Yeah, I mean, again, we're dealing with this entity that doesn't entirely exist yet. So, but I mean, presumably One Ohio would, once once it is a real thing. Although, you know, it is, as you said, sort of entangled with the government as well. So it's not clear that they would. Given, I mean, they would presumably have standing. It's not clear that politically they would challenge the political appointees who are you know, controlling a lot of their process to start with. I mean, One Ohio also has this interesting, you know, regional structure that you mentioned at the beginning, Dennis, that, you know, once it's up and running and is funding different entities at the local level, presumably those entities that are getting funding through One Ohio would also have standing to challenge if the money starts getting diverted elsewhere.
So the entanglement with government is even more complex than the complex we've talked about here. For example, the agreement limits the executive director's salary to being level 42 in state government, which is about $110,000. So can you really get a qualified executive director who has 5 years public health experience and all this for 110? So the plan is to, oh, that only comes out of the agreement, but the rest of his salary, like, it easily could be a 250 or 300,000 salary for a competent person, will come from elsewhere, maybe like the McKinsey settlement. So all of that once again gets into sort of a nebulous area that, you know, the governments can control. So so there's a question, and I guess for Micah or anyone, how will the 30% be distributed to local governments?
So I mean, there's the piece that goes directly to local governments, and I mean, the agreement itself spells out in minute detail how much money goes to each local government that is a party to the agreement. So I don't know. You might know more than I do about the details of that formula, but you know, it's you know, depends largely on I think the size of the jurisdiction. So it's, you know, Columbus gets a pretty good amount compared to most other places around the state.
So a concern that some people have is, like, my little town of Granville will get 10,000 over 15 years. You know, like, how can they intelligently spend it? And it's very similar throughout. So I think that the idea is that they would be encouraged to kick it back to the regional foundation. And I would think a large share would, but I would also think that people with a stake at it can go to the Chillicothe City Council and say, we have something good going on. So it gets to the how will One Ohio be held accountable? It's in the political process for better or worse, unless the legislature tries to take it away, and then it's in a different political process. So a question I'll throw to anyone is, how quickly do you think the money can get out the door and make an impact once the foundation is up and running? So you sort of have some experience in turning around big governmental projects, Micah.
Well, again, I mean, you have to actually, if you're talking about the One Ohio money, I mean, it needs to get up and running and hire staff. And if they're going to do, you know, grant making, all of those things will take time. So I think it would take, I don't know that I have a specific prediction, but you know, if the money's going to start coming in soon, like they actually really need to get this foundation up and running if they're going to, you know, have any realistic chance of spending the money in a timely way. But I don't know. I would guess, Dennis, you've probably been watching this closer than I have.
I don't think anytime soon, and I don't think that's a bad thing, because to get a sense of scope, the state opioid response grant from the federal government is $96 million, and the state has trouble spending it wisely at all when it comes in. So I think it'll be at least a year, and we're small and we have a hard time spending money wisely when it comes in. Also, an unsettled question is whether it has to go through the Ohio Controlling Board. For people who don't know, Ohio has this, I think only in Ohio, every expenditure of 50,000 or more has to get approval from a little board of 4 legislators. And does the One Ohio have to get that approval if it's unsettled? So there's also, like, you probably read it, Micah, Patty, and maybe even Tasha, there's an 8-page document of abatement strategies that the money can be spent on. And it sort of is everything in the kitchen sink. It's pretty good in public health. The only difference worth noting is that the national abatement strategy did not have law enforcement. Ohio did its own, and the only significant thing added was law enforcement task force, which I believe there's no legal challenge, but I did find that a little offensive, that people died and they're going to use the money to criminalize them rather than to save their lives. Does not seem appropriate. But the lawyers tell me, it's Ohio's agreement anyway, so be it. But if you all had a chance to take a look at any of the abatement strategies and have any ideas on whether that's a good thing and how it might work?
I have not looked at it in detail. I mean, I scanned it. I do think the law enforcement piece is problematic, as you mentioned. I really think the language of public health being co-opted by law enforcement is deeply problematic. The other thing that I think is probably less than ideal from a public health perspective is that it's a long list and a flexible list, but a pretty specific list. So to the extent that the opioid crisis is being driven by broader social determinants of health and sort of cross-cutting issues that are not specifically about opioids, it is limiting the ability of the money to be spent on programs and projects that are trying to address issues of racial disparities, issues of poverty, issues of health inequities more broadly. I mean, they could maybe be flexible about that to some extent, but the language is really specifically focused on opioid treatment and prevention.
So we have just a few more minutes. Let me ask Patty and then Tasha a final question. Is Patty used to be an FDA lawyer, and in the Perdue Pharma agreement, Perdue Pharma essentially in bankruptcy gets turned over to the plaintiffs. And one of the important things in it is that Perdue Pharma would introduce over-the-counter naloxone in a generic version. And I was just getting your thoughts from your FDA experience. That sounds great to me. Is that something that is doable and desirable?
Yeah, I mean, I think so. So for folks who know, naloxone is sort of available without prescription in many states. Generally, under federal law, it's still a prescription drug. And the way it's available without prescription is that federal law, so FDA says prescription or non-prescription, and then states say who may prescribe. So the Department of Pharmacy could have a sort of general prescription that applies to anyone. So anyone could get the drug directly from a pharmacist without a prescription from a physician. So, I think one of the barriers to FDA approving naloxone over the counter has been that companies have not asked for it. So generally FDA does not, there are arguments FDA can force a switch from prescription status to over the counter, but it really hasn't done that before. And so this is removing that obstacle to FDA approving the drug over the counter. So I think it'll be an interesting thing to watch.
And it could make a big difference on price. Right now, the public interest price, the harm reduction Ohio State government pays is $75 per kit. The Ohio State Wexner Center and others would pay like $100 to $110, but a generic over-the-counter could easily cut it to $30, $20 or less per kit, and that would increase access.
Right. So typically, because insurance won't cover over-the-counter products, they're generally priced much lower than prescription products.
So Tasha, let me finish up with a question for you. Is you showed in a chart on how prescription overdoses in Ohio had declined dramatically over the last 10 years or so. However, overdose death has increased dramatically as they had declined. So thinking like a lawyer, if you were assessing like liability and who caused what, how can you say that it's the pharmaceutical industry that caused it, when in fact, overdose deaths in Ohio were only like 1,350 in the biggest year, and now they're 5,000 when people cannot access prescription opioids.
Yeah, so I think this points to those qualitative, the qualitative data that I presented from participants. So, the prescription opioids were kind of like the introduction to opioids for many individuals. And then when we started these kind of campaigns to limit prescriptions to individuals and the availability became more difficult for access, then that kind of led to this transition then to heroin. So while we may not be seeing large numbers of deaths from prescription opioids, they were kind of the driver from that transition into the more potent opioids such as heroin. And now that heroin has been replaced with the more potent street fentanyl that we're seeing now, that's just increasing overdose. So I think there is that root tracing back to the prescription opioids. And I think just the way that we kind of addressed and started limiting the prescriptions there, that it really impacted what we're seeing now in Ohio as far as overdose deaths.
So it's sort of it started their argument, but is there also an argument that our response to it, rather than lowering overdose death, in fact, did the opposite and increased it? And outside of sovereign immunity, is there liability, public nuisance for bad policy that's causing 5,000 deaths a year?
Yeah, I think we need to look on the policy level and how I think in our response to, as we move forward, there's kind of a focus on, drug interdiction, looking at fentanyl, stopping the source, but I think we need to really invest our efforts into more prevention of overdoses. So things like harm reduction, the expansion of naloxone, and our policies that we have in the state. I think we really need to look at, are we supporting harm reduction for individuals? So we still have fentanyl test strip bans here in Ohio. So for individuals who want to engage in drug trafficking and want to reduce their overdose risk, we still have those bans. And paraphernalia laws, when in my conversations with individuals, paraphernalia laws are still being enforced. So I think we really need to look on the broader scale policy as far as what we're doing that are impeding efforts for individuals to actively engage in risk reduction, because individuals are actively engaging in these risk reduction practices, but we're not necessarily supporting that.
Thanks, Tasha. So maybe we'll wrap it up with like Micah, Patty, and Tasha having like a final comment. So we'll go, since you're on the left of my screen, Micah, we'll go first with you. You're muted there, Micah. So if you unmute us,
got it. Sorry. No, I mean, I think this is a lot of money that's going to come in very quickly, and I take your point, Dennis, that we should be thoughtful and not necessarily rushing how we get it out the door. But I think I don't know how many law students again that we have on here. I think there are a lot of unsettled legal questions here, and this entanglement of this quasi-private entity with the state is an entirely new thing. So for those who want to kind of wade in and do some writing on some new and uncertain legal issues, I think there's a lot to look at here.
What do you think, Patty?
Well, thanks everyone for joining us, and thanks Dennis, Micah, and Tasha for your helpful comments. I guess I would just add that I think one interesting, maybe slight conundrum here is maybe the tension between making sure the money is used in ways that address the opioid crisis and holding One Ohio accountable while still allowing flexibility for the kind of broader public health approaches that Micah mentioned. So if we want that money to be used for things that address maybe root causes of the opioid crisis that aren't directly about opioid use, or how do we enable that?
And yeah, thanks to everyone who joined us today. Thanks to Dennis, Patty, and Micah. And I'm excited to hear the rest of the panel series and those perspectives on, where this money might be be spent. Obviously coming from someone who's interviewed people who use drugs, definitely hope that we can support those efforts in reducing risks and in reducing overdose deaths in Ohio. So just looking forward to kind of seeing the rest of the panels and also seeing how this money will be spent here in the state.
Thanks very much to everyone.